Hola a todo el mundo y bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina ya practicando las leyes criminales, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar. Bueno, espérate. Vamos a empezar hablando de Alex Murdaugh. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination. Wait. With true crime cases. Listen. Okay, I think I messed that up today, but that's okay. If I never told you guys, and for the new watchers or whatever, the reason I do that is to show off my nails. There's usually a fascination with my nails, and I don't know why that is. Probably because I'm an attorney and you guys expect me to look a certain way, and I don't fit that stereotype, but that's okay. So listen. Okay, you guys, in the midst of all of the David debauchery and all of the coverage that we've been doing on the David case, it came to my attention that relatively recently there was a new trial granted for a very prominent ex-lawyer. And, you know, today we're going to talk about it. Today we start our coverage on the case of Alex Murdaugh. So basically what happened is this. Richard Alexander Murdaugh, or Alex Murdaugh, was a former and prominent South Carolina attorney. On March 2nd of 2023, he was convicted of killing his wife and his son. The very next day, on March 3rd of 2023, he was sentenced to 2 life sentences for those convictions. Now, all of a sudden, I'm hearing that he's getting a new trial. Was it an appeal? Was it something else? Did the appeal work? Was it under some other rule? I'm here to explain it all to you. Let's go ahead and get started. Okay, you guys, so after he was convicted, he did file an appeal, but it's my understanding that the new trial that he was granted did not come by way of that appeal. And I know it sounds crazy, but as always, if you guys stick with me long enough, I'll explain it. Basically, what happened is this. Although Alex filed a notice to appeal, or filed the appeal in this case, he sought leave from the appellate court to stay the motion for the appeal on grounds that new evidence was discovered, and so that he could file a motion pursuant to South Carolina Rule 29B and grant a new trial, or get a new trial by virtue of that statute. Does that make sense? I'll try to repeat it a different way. What I'm saying is this. There was an appeal in this case. He asked the Court of Appeals to stay the appeal, so to not rule on it just yet, because he had to file a timely motion under another rule, South Carolina Rule 29B, based on new evidence. And because of that, he didn't want the Court of Appeals to rule just yet. Now, why would he do that? In my review of the rule, basically what it says is you cannot file a motion under this rule if an appeal is still pending. So you have to have leave and stay the appeal in order to file a motion under this rule. Does that make sense? It doesn't matter if it does or not, because guess who's going to read it to you? Let's go ahead and get started and go into what that rule says. As you guys can see here, South Carolina Rule 29 for post-trial motions. B says the following. New trials based on after discovered evidence. A motion for a new trial based on after discovered evidence must be made within 1 year after the date of actual discovery of the evidence by the defendant, or after the date when the evidence could have been ascertained by the exercise of reasonable diligence. A motion for new trial based on after discovered evidence may not be made while the case is on appeal unless the appellate court upon motion has suspended the appeal and granted leave to make the motion. Leave of the appellate court is not required if no appeal has been taken or if the appeal has finally been decided in the appellate court. So basically, what does that mean? It means what I said to you guys. He did file the appeal, but he asked the Court of Appeals to stay the appeal so that way he could file a motion under this specific rule. Now, what was the newly discovered evidence that Alex and his attorneys were citing? Well, basically what they're saying is that the court of clerk didn't mind her mother effing business, and she didn't do her job, and she was lacking in professionalism, and in essence, she tampered with the jury. And because of that, they wanted to file a motion for a new trial. I'm going to go ahead and just read the order that was issued so you guys can have a better understanding of the timeline and just verify what exactly I'm saying. As you guys can see here, it says the Supreme Court of South Carolina, State of South Carolina versus Richard Alexander Murdaugh, the defendant. Order says the following. Defendant was convicted of the murders of Margaret Kennedy Branster Murdaugh and Paul Terry Murdaugh on March 2nd of 2023 and sentenced on March 3rd of 2023. Defendant served and filed a notice of appeal to the Court of Appeals and on September 5th of 2023 sought leave to file a new trial motion in the Circuit Court pursuant to Rule 29B of the South Carolina Rules of Criminal Procedure and to suspend the appeal during the pendency of the motion. The Court of Appeals granted the motion on October 17th of 2023 and defendant filed a motion for a new trial with the Colleton County Clerk of Court on October 27th of 2023. By order, dated December 18th, 2023, the Honorable Jean Hofel Toll, retired Chief Justice of the Supreme Court of South Carolina, was assigned exclusive jurisdiction for the limited purpose of presiding over defendant's motion for a new trial in the above matters. Because defendant's motion for a new trial contains allegations related to the conduct of the Colleton County Clerk of Court, I find it would be inappropriate for documents in this case to be filed in Colleton County. Therefore, it is ordered that all documents, orders, and correspondence related to the resolution of defendant's motion for a new trial shall be filed with the Clerk of the Supreme Court of South Carolina. Upon receipt of this order, the Clerk of Court of Colleton County shall transmit a copy of the defendant's October 27th motion for a new trial together with any and all subsequent filings in the above cases to the Clerk of the Supreme Court of South Carolina. Now, why exactly did I show you guys that? Kind of because it verifies what I'm explaining to you. As I said, he did file a notice of appeal. He then discovered new evidence, i.e. the court clerk tampering with the jury. He wanted to file a motion for a new trial, but under Rule 29B of the South Carolina Rules of Criminal Procedure, he couldn't do so if the appeal was pending. So he asked the South Carolina Supreme Court to stay the appeal. I'm lying. He asked the South Carolina Court of Appeals to stay the appeal so that it could be decided whether or not he was granted a new trial under this separate rule. Are we catching it? Y'all got it? Does it make sense? Does it make sense? Okay. Now, wouldn't it be lovely if we somehow, by some means, were able to gather the motion for a new trial that he filed? Don't worry, because I got you. Here it is. And we're going to go through it together right now. As you guys can see, it says the State of South Carolina and the Court of Appeals appeal from Colleton County, Court of General Sessions, Clifton Newman, certain court judge, appellate case number 2023-000-392. The state is the respondent, and Richard Alexander Murdaugh is the appellant. Motion to suspend appeal and for leave to file motion for new trial. Appellant Richard Alexander Murdaugh, pursuant to Rule 29B of the South Carolina Rules of Criminal Procedure, hereby moves for leave to file a motion for a new trial based on after discovered evidence in the Court of General Sessions and to suspend this appeal during the pendency of the motion. Appellant offers a copy of the motion for a new trial attached as Exhibit 1 with its own exhibits labeled Exhibit A through Exhibit 1. As the memorandum in support of this motion and documents supporting facts relied upon, not contained in the record on appeal as required by Rule 240 of the South Carolina Rules of Appellate Procedure. Now we're going to stop right there. And I know I'm going to sound like a broken record a lot during this video, but I just want you guys to understand it, okay? So again, he did file an appeal. This is his motion to the Court of Appeals, asking the Court of Appeals to suspend the appeal for right now because he wants to file another motion pursuant to South Carolina Rules of Criminal Procedure 29B, which says that they cannot file a motion under that specific rule should an appeal be pending. Does that make sense? Are we getting it? Do you guys understand? Oh, okay. I hope you guys understand. So anyways, let's continue on into what else he said. Motion for a new trial. Defendant Richard Alexander Murdaugh, through undersigned counsel, pursuant to Rule 29B of the South Carolina Rules of Criminal Procedure, hereby moves the court for a new trial after discovering that the clerk of court tampered with the jury by advising them not to believe Murdaugh's testimony and other evidence presented by defense, pressuring them to reach a quick guilty verdict, and even misrepresenting critical and material information to the trial judge in her campaign to remove a juror she believed to be favorable to the defense. Specifically, during the trial, the Colleton County Clerk of Court, Rebecca Hill, instructed jurors not to be misled by evidence presented in Mr. Murdaugh's defense. She told jurors not to be fooled by Mr. Murdaugh's testimony in his own defense. Ms. Hill had frequent private conversations with the jury foreperson, a court-appointed substitution for the foreperson the jury elected for itself at the request of Ms. Hill. During the trial, Ms. Hill asked jurors for their opinions about Mr. Murdaugh's guilt or innocence. Ms. Hill invented a story about a Facebook post to remove a juror because she believed the juror might vote not guilty. Ms. Hill pressured the jurors to reach a quick verdict, telling them from the outset of their deliberations that it, quote, shouldn't take them long. Ms. Hill did these things to secure for herself a book deal and media appearances that would not happen in the event of a mistrial. Ms. Hill betrayed her oath of office for money and fame. Once these facts are proven, the law does not allow the court any discretion about how to respond. It must grant a new trial. Okay, you guys, let's just stop right there and give you my opinions on that very first segment that we just read. Do I agree with them that if Ms. Hill was tampering with the jury and telling them what to say and doing all of these things, that the court must grant a new trial? I absolutely do. I'm trying to think exactly what the oath is. So don't completely just hold me to these words, but I know for a fact that the court of clerk is sworn in whenever the jury goes back for deliberations. And the oath is something to the effect of like, Mr. or Miss so-and-so, do you promise to keep this jury convened in one safe and convenient place and not to bother them or something like that, right? So she took that oath before the court, before she took the jurors back, and then still disobeyed that oath and told them what to do, what to think, how to say, and all of these things. Nah. I know we are disappointed that he's going to get a new trial. Okay? I get it. We feel a certain way about it. However, if they were able to prove these things to the satisfaction of the court, which obviously they were because a new trial was granted, it is absolutely the proper procedure for him to be granted a new trial. Does that make sense? Let's go ahead and carry on into the next segment. Statement of facts. Mr. Murdaugh was indicted for the murder of his wife Maggie and son Paul on July 14th of 2022. His murder trial began on January 23rd of 2023. The presiding judge was the Honorable Clifton Newman. The trial ran for 6 weeks, ending with convictions on the evening of March 2nd, 2023, and sentencing on March 3rd, 2023. The state rested its case in chief, and defense began its case on Friday, February 17th of 2023. Court was not held on February 20th, which was President's Day. After returning from the holiday, Ms. Hill began to enter the jury rooms often. As the defense began its case, Ms. Hill told jurors, "Y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you." Additionally, Ms. Hill and juror number 826, the new jury foreperson, on multiple occasions went to another room to have private conversations lasting 5 or 10 minutes. Sometimes they would go into the jury room's single occupancy bathroom together. Foreperson juror number 826 never said anything about the content of those conversations to the other jurors. Ms. Hill even instructed jurors they could not ask foreperson juror number 826 about the conversations. 2 days later, and on Thursday, February 23rd, and continuing through the next day, Mr. Murdaugh testified in his own defense. Before he began his testimony, Ms. Hill told jurors not to be fooled by the evidence Mr. Murdaugh's attorneys presented, which at least one juror understood to mean that Mr. Murdaugh would lie when he testified. Ms. Hill also instructed the jury to watch him closely, to look at his actions, and to look at his movements, which at least one juror understood to mean that Mr. Murdaugh was guilty. Immediately after Mr. Murdaugh testified, foreperson juror number 826 told the jury that Mr. Murdaugh was crying on cue. She also criticized the former foreperson, juror number 589, for handing Mr. Murdaugh a box of tissues when he was crying on the stand because that is what defense wants us to do. The next court day, after Mr. Murdaugh's testimony, Monday, February 27th, Ms. Hill told Judge Newman about a Facebook posting she purportedly saw on the evening of Friday, February 24th, the day Mr. Murdaugh's testimony concluded, while perusing a Facebook group page called Walter Burrow Word of Mouth. The post, purportedly by juror number 785's ex-husband, Tim Stone, allegedly stated that his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be. Judge Newman asked her to produce a copy of the posting. She could not produce a copy, but according to Ms. Hill, a subordinate employee in the clerk's office, Lori Wise, discovered that the post was taken down and replaced with an apology post. Folks, I posted a ugly post yesterday to which I have deleted, and I kinda in a roundabout way directed it towards a certain person, and I would like to apologize to everyone who read it that ugly for me to do that. And yes, I let Satan control me and I broke down and started drinking, and when I was drunk, I made the post and I'm sorry. The apology post states the initial post was already deleted on February 16th, so it would have been impossible for Ms. Hill to see the original post on February 24th. I'm going to stop right here. Is what we're reading right now rather concerning? Absolutely. Because not only is she telling the jurors what to say, what to think, what to feel, and what to opine, she's also fabricating evidence that a post existed to try to get a juror disqualified from jury service merely because she believes the juror would be preferential to the defense. Do you guys see how that's problematic? Anyways, you guys, let's go ahead and carry on. Mr. Stone, juror number 785's ex-husband, avers in a sworn statement that he made no such posts. Mr. Murdaugh has obtained an authentic download of the entirety of Mr. Stone's Facebook activity from January 23rd, 2023 to March 2nd, 2023, which confirms he did not post the apology. The supposed original post, if deleted, would not be recoverable at this point under Facebook's retention policies, and that he in fact never posted anything to the Walter Burrow word of mouth Facebook page during the trial. The person who made the apology post is an unrelated person also named Tim Stone, whose Facebook profile picture is not juror number 785's ex-husband. Let's go ahead and stop right there. So although this is absolutely asinine, that a court of clerk would behave in such a manner, is it also conceivable, because I'm trying to give everyone the benefit of the doubt here, that she might have mistook this for someone else and they have the same name and waddy wop wooty whoop? I guess just a little bit. But let's be honest here. When you're dealing with something of such high caliber, it is incumbent upon you to be certain when you say such treacherous things. So to go to the court clerk, I'm sorry, she went to the judge. She is the court clerk. To go to the judge and be like, Judge, I saw a post from such and such juror's ex-husband and it said watty wop wooty whoop, without knowing or being certain, is disgraceful. But let's go ahead and carry on. On February 28th, Ms. Hill questioned juror number 785 about the fictitious post on Walter Burrow word of mouth alone in her office in the courthouse. She told juror number 785 that someone had emailed her stating her ex-husband, Tim Stone, posted on the Walter Burrow word of mouth Facebook page that juror number 785 had been drinking with her ex-husband and that while drunk, she expressed opinions on the guilt or innocence of Mr. Murdaugh. Juror number 785 told Ms. Hill that never happened, that she had not seen her ex-husband in 10 years. Juror number 785 asked to see the post, but Ms. Hill would not show it to her. Ms. Hill directly asked juror number 785 whether she was inclined to vote guilty or not guilty. Juror number 785 said she had not made her mind up. I'm going to stop right here, and you guys are going to get tired of me inserting my opinions, or maybe not, because that's why you come for these videos, but that's totally improper. You are not supposed to intervene with the jury at all, at any point of their deliberations. So to ask this woman whether or not she was going to vote guilty or not guilty is such an improper question. You guys, this is getting crazier and crazier by the moment. Later that day, Ms. Hill told juror number 785 that SLED and Colleton County Sheriff's Office personnel went to Mr. Stone's home and he confirmed he made the post. This is a fabrication by Ms. Hill. Ms. Hill told juror number 785 she would somehow reinstate a restraining order juror number 785 previously had against Mr. Stone, which is something that Ms. Hill did not have the authority to do. We're going to pause right there just to tell you guys one more thing. Well, one more thing for now, let's say. I think it is radical. It's just absolutely, I'm running out of words how to describe the treachery of this woman, right? So defense went and downloaded the Facebook post of Timothy Stone, okay? And Ms. Hill is over here saying, well, someone went over to his house and he confirmed he made the post, and then goes back to the juror to tell her that. But it's like, lying for what, ma'am? Let's carry on. Still later that day, Judge Newman examined juror number 785 regarding both the non-existent Facebook post and the tenant coworker email. Juror number 785 described her interactions with Ms. Hill regarding the Facebook post. She denied making any inappropriate comments about the case to third parties and stated she wanted to hear closing arguments before forming an opinion on Mr. Murdaugh's guilt or innocence. After she was dismissed, Judge Newman said, "Oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me. He was right to be concerned." Let's stop right here again, okay? Do you guys know how alarming it is that the court took the Court of Clerk's word about the fact that this juror was lying and dismissed the juror despite the juror telling the court, no, that didn't happen. That did not happen. And here's what I'm telling you. And then on top of that, you know the court knows that it messed up, right? Because it said, hey, I'm not too pleased with my clerk going out here interrogating jurors. That's interesting. The next day, on March 1st, 2023, the jury visited Moselle, the site of the murders. During the visit, four-person juror number 826 and Miss Hill walked off to have yet another private conversation. In her book, Miss Hill more vaguely hints at communicating her opinion on Mr. Murdaugh's guilt to the jury during the visit to the Moselle property. While the jurors viewed the Moselle property, we all could hear and see Alex's story was impossible. Some of us, either from the courthouse, law enforcement, or jury at Moselle, had an epiphany and shared our thoughts with our eyes. At that moment, many of us standing there knew, I knew, and they knew Alex was guilty. That day, Judge Newman also held an in-camera conference regarding the tenant-co-tenant email in which he decided to revisit the Facebook post issue with Ms. Hill. The court. Okay, well, let me see what Becky is talking about. I wanted to revisit the Facebook post that you mentioned yesterday. Ms. Hill. Right. The court. That's Becky Hill, the Court of Clerk. Can you tell us about the Facebook post? Ms. Hill. Yes, I think it was Friday evening. Just for a brief moment, I perused Facebook, got on Walter Burrow word of mouth, and saw where someone had said that, well, it was the ex-husband of a juror, and he said that he had noticed his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be, and that he was the ex-husband, but she was known for talking way too much. And then I just kept going on scrolling because that was enough for me. I've gotten enough. The court. And how did you determine who he was talking about? Ms. Hill. When I heard there was an email on Monday, I figured the two went together if it was true. The court. Well, she confirmed that she has an ex-husband who she has 3 restraining orders out against. So, Ms. Hill. Right. So then we looked on Monday after you told me to try to go look back and look for it, and we couldn't find it. But when we found out his name and we found out the post and printed it out where he said that he had put something up, but that he had deleted it at the time, that he had put stuff out there wasn't nice. The court. He said he got drunk afterwards. Mr. Meadows. Something about the devil. Mr. Harpootlian. Didn't he say it was Satan in it? Miss Hill. Satan was in it, yes. In all of the details, yes. The court. All right. Miss Hill made me do it. The court. Okay, I just wanted to have on the record you're reading a Facebook post by the ex-husband who said it. Of course, you haven't talked with him, so you don't know where he got this information from. Miss Hill, I don't. I can find it, though. But Miss Hill never saw any such Facebook post. She made it up. Further, she knew the apology post was not posted by juror number 785's ex-husband. Juror number 785 showed Miss Hill a picture of her ex-husband, which is not the Facebook profile photo of the other Mr. Stone's post about Satan. Let's stop right there. You remember the little kudos or the little bit of grace or the little bit of whatever I was trying to give Miss Hill? I take it back. I take it back. So she had a photo of who the actual ex-husband was, but instead of not fabricating this entire story and putting everyone in this position, she decides to do so anyway for her own nefarious purposes. This woman is evil. Let's continue. The next day, March 2nd, 2023, the day of the verdict, juror number 785 received a call from her ex-husband that she did not answer. The call upset her because Miss Hill's lies had led her to believe he was posting on Facebook about her and might be stalking her. Juror number 785 asked to speak with Miss Hill. She told Miss Hill she was scared. Miss Hill told her that the Murdaughs probably got him, meaning her ex-husband. Miss Hill once again asked her opinion regarding Mr. Murdaugh's guilt. Juror number 785 told her that Creighton Waters' closing was good, but she still had questions. Miss Hill asked what questions, and juror number 785 replied that she was concerned that no murder weapon was found. Miss Hill then asked, well, what makes you think he's guilty? Juror number 785 said Paul's video at the dog kennels. Miss Hill then told juror number 785 that everything Mr. Murdaugh has said has been lies, and I should forget about the gun. They will never be seen again. Miss Hill then told juror number 785 about the views of the rest of the jury, telling her that if the foreperson would just go in and ask for a raise in hands, this would be over and done with, and everyone needs to be on the same page. Juror number 785 went to the jury room and 10 minutes later was excused from the jury. In open court, immediately after her excusal, juror number 785 asked Judge Newman if he had spoken with the court of clerk, referring to the conversation earlier that morning with Ms. Hill. Judge Newman responded that I have not spoken with her today and that it is totally independent of any conversation regarding her ex-husband, apparently misunderstanding her question to the reference of the issue of the Facebook post. When the jury began deliberations that evening, Ms. Hill told them this shouldn't take us long and that if they deliberated past 11 p.m., they would be taken directly to a hotel even though none were prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks as they had previously been allowed to do during the 6-week trial, but Ms. Hill told them they could not smoke until deliberations were complete. There were 6 smokers on the jury. Ms. Hill told jurors that after the trial they would be famous and predicted that media would request interviews with them. Ms. Hill even handed one reporter's business card to jurors during the trial. Juror number 578 took this to heart and made an appearance on Good Morning America the night of the verdict, which is why on the day the jury began deliberations, he wore a suit coat for the first time during the trial. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group of reporters from network news shows. She traveled with jurors to New York City when they appeared on the Today Show. She got her book deal. Her book, Behind the Doors of Justice, was released on August 1st of 2023. A last point about Ms. Hill's efforts to promote her book shows her dishonest efforts to profit from the trial continued well after the verdict. A film crew negotiated a contract with the Colleton County Sheriff's Department to use courthouse bailiffs to provide security while they filmed a documentary at the Colleton County Courthouse when it was closed for the Confederate Memorial Day on May 10th, 2023. The film crew had previously recorded an interview with Ms. Hill. On May 9th, Ms. Hill sent a memorandum to the film crew purporting to be an addendum on the contract. In it, she demanded that the film crew pay Colleton County a fee of $1,000 per day for use of the courthouse facilities and made a nonsensical statement about not having authority outside of South Carolina that reflects a failure to understand the choice of law clause in the contract. Then she bizarrely added a handwritten demand. Also, in exchange of the use of the likeness of Rebecca Hill in an interview, a minimum of unclear 5-second video and audio chips will accompany the usage on the first reference. The book cover for the book, Behind the Doors of Justice, The Murdaugh Murders, will be shown, and audio will include Becky's introduction as the clerk of court for Colleton County and author of the book. The film crew ignored her addendum, as the contract had already been executed. But like her jury tampering during trial, it was an attempt to violate South Carolina Code Section 813-700A, which provides, no public official, public member, or public employee may knowingly use his official office, membership, or employment to obtain an economic interest for himself. For the foregoing reasons, Mr. Murdaugh respectfully submits that the court must hold an evidentiary hearing to receive proof of the facts above. When those are proven, the court must grant a new trial. Okay, you guys, so we got through most of that together, and I say most of that because I skipped over the legal standard section that Murdaugh's attorneys wanted us to consider because I didn't want to read it. If I'm being quite frank, I didn't want to read it, but I can list the entire document for you guys to see it and read it on your own if you would like. If you have questions about it and you want me to go through the legal standard, I can do that in a separate video, but let me tell you guys my opinions. I think that the court properly granted him a new trial. I know it's a headache and I know it's a hassle and I know how we all feel about this man and whatever. The court properly granted him a new trial. Tampering with the jury to such a strong effect as Ms. Hill did is not something to be taken lightly. And, you know, we'll see what happens at the second trial. But I'm not going to say anything too cheerful, meaning I want us to keep in mind, just because a new trial is granted doesn't mean that he will all of a sudden not be convicted at the new trial. Okay. That's just, you know, there's always a possibility that he's going to be convicted again. That's all I'm saying. Right. And he's still in custody because it's my understanding that he was convicted on some other crimes and some other charges, and he's still serving more than 4 decades in custody. So he's not going anywhere until this new trial. But let me go one step further. Even if he didn't have those convictions, and even if he wasn't already serving sentences for something else, it's my opinion that he'd probably still be in custody waiting for this trial, because just like any other bail, bond hearing, what have you, argument for release, whatever, he still has pending now murder trials to face. Does that make sense? So I don't think he would be going anywhere anyway. So I want us to all rest assured that he's currently in custody, and hopefully this time justice will be handled far differently. But that is it for my Alexander Murdaugh video. Before I let y'all go, and I'm going to say it again because I notice that when I say it in these videos, you guys really listen. I enjoy talking to all of you. I love talking to you. I love talking to you. But it also takes time and effort and energy and what have you. So if you enjoy this video, can you please let me know? Just leave me a comment down below. Literally say anything in the comment. I see that my likes are increasing. I love that. But can you also comment too? Can you just tell me, Desiree, I love that. Just say anything. Literally say anything down below. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.